So, good afternoon. We will continue to tackle the Chapter 13, Forensic Examination or Printed Photocopy Documents. Examination of computer-generated documents. In the digital era, computer, typesetting, electronic fonts, and graphical user interface, modern digital computers and output device can conveniently produce image and text and documents. Examination of computer-generated in our era is, in this age is, gikan sa una is, ang mga gamit ng mga computer is nagpa-upgrade abot sa common nga generation is nagka-high-tech ng paggamit sa mga computer nga ilang gamiton to to write or sa paghimo sa isa ka documents. First, the question can be used in guide examination process. Amoy ng mga guide examination process sa pagkuhan na pag-determine sa isa ka documents kung original or kung kini ba is kung na kaning gi-copy or first is the document an original or copy. The forensic examiner is to determine nga if the evidence is original machine printed or documents copy. So amo ning taglaong na ang isang examiner is tanaw kung ang isa ka documents kung kani ba is original ba or na documents or sa machine gikan na copy or sa kuan ra kanang sa watermark. Second, can printing technology be identified? So ang kaning technology is tanaw kung kaning nga documents kung identifying printing technology means attempting to classify printing process. Microscope examination can help determine if the document has been printed in color or black and white using impact or non-impact process with toner, with ink, another medium. Third, has more than one technology been used to prepare documents. Usually applies to documents with reinsertion and page substitution. In insertion documents, place back into a printer after the parties have signed agreed terms in documents. For example, is the signature of deed of sale is left intact but preceding pages are replaced. Fourth, in a multi-page document, is there evidence that one or more pages are prepared differently than the others? So opposed question involves ang isa kakuan is ka document is mag-compare sa mga magtanaw sa mga lahi-lahi nga mga mga documents para kung ini ba nga printer is parehas ra ang gigamit nga din ang sa mga punctuation tanong formation tanong sa spelling tanawon sa isa ka part sa documents. Then kung ano sa dasab na date ini na print and then kung ano na kuanang gamit printer. Fifth, is there any evidence that text has been altered or added to documents? Examining alteration in computer-generated documents means determining of text has been added or altered in the same way pages were substituted in the previous question. There is ang isa ka evidence is tanawon kung ang kanibang nga documents is nga itong pulihan sa isa mga pages din tayo tag reinsertion din tanawong mga spacing line din ang font din layout sa text sa nanang spacing. Are there any obvious gross defect of printing usually to machine being individualized? Defects are rare and problems point to ink or toner cartridge and other replaceable components. The best way to identify the printer in case is to get samples of the printer output. Mangguha ko ng mga samples sa mga lain-lain ng mga printer kung unsa rin yung mga gamit sa isang question documents. Then We proceed to examination of photocopy documents. Photocopier are widely used business nowadays because their ability to create fast, expensively documents, punctuation printing mechanism or inkjet printing copier exhibit the same characteristic and therefore require the same method of examination. Is able to identify ang isa ka individual copier document summary can do the following. First, determine whether or not two or more copies from the same machine. Second, determine whether or not a particular machine produced the copies. Third, determine the proximity date of the copies. Then we proceed to chapter 14. Presentation of evidence in a court. Presenting of handwriting evidence sa court. In presenting ng evidence on handwriting, forensic documents or giving testimony on expert witness should be prepared to explain his findings extensively, exhaustively. So, ang isa ka pag-present sa court ng handwriting evidence sa isa ka examiner is first i-studyhan niyang tanan nga maghimo sila conclusion or discuss nila ng brief explain the principles sa method kung sa igamit sa pag-apply sa isa ka handwritten documents. First, some document examination documents chart doon the question writing justification so that the comparison between them can demonstrate following serve guide to bring demonstrate chart. First, use black and white photographs of the documents, both known and question. The size of the handwriting visually increase to produce illustration details that of importance in the examination. Second, colored background that have no correlation. The writing can be removed from the photograph using filter. Make sure to leave them that features such as dotted lines or writing on forms or left to show how they relate to the writings. Third, good quality photocopies can be used instead of photographs. Use appropriate magnification and provide sufficient clear copies to demonstrate details necessary to demonstrate findings to the court. Third, the simplest way to prepare a chart to mount enlargement of complete documents on face on card so that they can be compared. Make sure to include sufficient writing on a chart to demonstrate how each letter made on how it compares with known materials. It might be necessary to provide copies for everyone in the court, including the judge, counsel, and defendant. When presenting the chart to the court, the expert witness should clarify where its examples appear on the question documents, both different and similarities in the letter. Features of handwriting should be noted. 8. Giving expert evidence in court is usually done with a question and answer with the counsel of the examination. 9 is the best way for the expert witness to use plain simple terms when explaining details of testimony. Then 10, after showing the details illustrated in chart, it is useful to reiterate the principle of handwriting comparison and repeat the findings. Presentation of other evidence. Then, presentation of other evidence daw is ang isa ka typewriting. If tanaw ng mga mag-compare, magkuha ka isa ka sa iyo pag-present sa isa kuhan is magkuha ka ng mga samples or parang kung kani ba nga handwritten is kaparehas-parehas ba para may determine kung kani is about kung ano itagamit na kuhan. Then, second, differences in ink. The difference between two inks used in a question documents can be shown through a photograph illustration of infrared reflection or luminescence used in documents. Different inks. Photograph taken documents using techniques can be shown an example of obliterated entry in a well putting the side by side with photograph the same document under normally high illustrated. Third is indented impression. When the evidence can be presented using indented impression, the expert witness must first explain how they came to be there. Oblique lightning photographs and transparencies produced by the electrostatic detection apparatus that show the impression can be presented in court. Let's proceed to chapter 15, Philippine laws and question documents. Revised Penal Code, crimes again in interest. Counterfeiting the great seal of government of Philippine Islands, forging the signature or stamp of the chief executive, using forged signature or counterfeit seals or stamp, forging treasury or banknotes under documents payable by importing the uttering such false or forged notes to documents, counterfeiting, importing and uttering instruments not payable to bearer, illegal possession and use of false treasury or banknotes and other instruments of credit, falsification of legislative documents, falsification by public officer, employee or notary or ecclesiastic minister, falsification by private individual and use of falsified documents, falsification of wireless capable telegraph and telephone message and use to send falsified message. False medicine indicates use false certification of merit or service, using false certificate, manufacturing and possession of instrument or amplification for falsification. Crime against public interest, forgeries, Section 1, forging the seal of government of the Philippine Island signature, stamp, and chief of the chief executive. Article 161, counterfeiting the great seal of government of the Philippine Islands, forging the signature of stamp of the chief. Ang penalty ni reclusion temporal upon sa person na nagsundog sa nag-forge great seal of the government of Philippine Island signature or stamp. Article 162, using forged signature or counterfeit or stamp, the penalty of prison mayor shall be imposed upon person who shall knowingly make use the counterfeit seal or forged signature or stamp mentioned in the preceding article. Section 3, forging treasury or banknotes, obligation and securities, importing, uttering false or notes, obligation and securities. Article 166, forging treasury or banknotes is or falsification of treasury, banknotes, obligation or other obligation security payable, bear an information and uttering connivance with forger or importer. Ang iya ini is reclusion temporal in its minimum period and fine not exceed 10,000 pesos. Documents were falsified, counterfeited, or altered as an obligation or security of the United States of the Philippine Island. By prison in its maximum period of fine not exceed 5,000 pesos. 5,000 pesos if the falsified or altered documents circulating not issued by using banking institution duly authorized by the law to issue the same. By prison mayor in this medium period and fine not exceed 5,000 pesos if the falsified or counterfeited document was issued by foreign government. By prison mayor in minimum period of fine not exceed 2,000 pesos when the forged or altered documents is a circulating note or bill issued by a foreign bank duly authorized therefore. Article 167, counterfeiting, importing, and tethering instrument not payable to bearer. Person shall forge, import tethering conveyance with forgery or imports instrument payable, order, or documents credit payable bearer shall suffer penalties, correctional in medium and maximum period, and fine not exceeding 6,000 pesos. Illegal possession of use false treasury or banknote and other instrument to credit is ang iyang penalty next lower than the prescribed sa article. 169, how forgery is committed. The forgery referred to the section by committed in the following: by giving a treasury or banknote or any instrument payable to bearer or order mentioned therein the appearance of union documents.
Article 168. Example na is ka ng mga chiki na intention ito niya kabalo siya na piki yung mga piki ang iyang gawira na chiki pero iyang gigamit na pansa na mga pang-grocery ba na may mga grocery na budawat ng mga chiki.
Falsification of legislative document. The penalty is correctional of its maximum period and fine at exceeding 6,000 pesos shall be imposed upon any person who without proper authority therefore alter any bill, resolution, or ordinance enacted or provide or pending approval either House of Legislative or Provincial Board or Municipal Council. Article 171, falsification by public officer, employee, or notary or ecclesiastic minister. The penalty is prison mayor and not fine exceeded 5,000 pesos. Then Article 172, falsification by private individual and use falsified documents. Ang iyang penalty is prison correctional in medium o maximum period. Ang iyang fine is more than 5,000 pesos. Article 173, falsification of wireless cable, telegraph, and telephone message and used falsified message. Penalty is prison correctional in medium maximum period shall be imposed of an officer or employee of the government of any private corporation. Section 5, falsification of medical certificates or merit or serves indicates Article 175, using the false certificate, penalty of arrest to minor shall be imposed. Article 176, manufacturing and possession of instrument or implement for falsification, penalty is prison correctional in medium maximum and a fine not exceed of 10,000 pesos.
Falsification of a fake.
Ang kalayan sa falsification of forgery, ang falsification is makuha nga dali mo determine nga dali mo na fake siya. Ang sa forgery is kuha siya ibali examine niya na siya mga diba sa chiki example kuha siya original siya na chiki na siya yung ilisdan daw either mga pangalan bitaw pangalan nila di siya may bawaan mo na kuha na fake siya
unless imong i-examine. Like a manufacturing possession of instruments or implements for falsification. Kumbaga, nag-possess ka ng mga ibang documents nga kabalo ka nga fake adto. So, naakay ka na ang madawat nga penalty kay nag-possess man ka na mga inglanan ng mga gamit nga nagpatunay nga nakan mga documents sa gawiran which is fake kabalo ka nga fake kay falsification na kagamit dili manang kanang forge.
Presentation of evidence. Section 1, examination to be done is in open court. The examination of witness presented in trial or hearing shall be done in open court under the oath or affirmation unless the witness is incapacitated to speak or question calls for different mode, answer, and question of the witness shall be given orally. There is ang isa ka kuan magpresent sa sa court ng kuan mahungan ng kibayang examination is sa mga himo ni sa kanang kuan gani trial din mo kuan raw isa ka mo tiyog raw isa ka ano ba sa witness kung tawagon mo sila kung sa iya ikuan
ang quandary ang sa examination of witnesses dito section ng examination to be done in an open court. It means down during examination ibalik kabalo kana ang pag mahibalaan nga nag-possess ka na isa ka isa ka documents na falsified pag mapatunayan dyan during sa examination ato nga document imo na siya sa open court which is pwede bisag sikin sa ang maka-witness during sa examination nga document nga gipossess nimo which is falsified na siya sa examination in open court.
Proceeding to be recorded. The entire proceeding of trial of hearing or hearing court question propounded to a witness of his answer to the statement made by the judge or any of the parties, counsel or witness with reference to the case shall be recorded by means of shorthand or stenotype or by other means of recording found suitable by the court. The transcript record of the proceeding made by the official, stenographer, stenotypist or recorder and certified correct by him shall be deemed prima facie according statement such as proceeding.
So the proceedings to be recorded is, it means during sa examination anything na makita sa during sa examination or kanang dipang istorya sa during sa kanang court kailangan recorded na siya either dyan mga video record or dyan kanang ginahimo minting nga stenotype which is typewriting na gani mga nagipang na sa proceedings to be recorded di ba dyan ay isa katawo sa gilid nga may magsigig type during while ang uban ang kanang attorney or mga prosecutor or ang judge ng istorya kanang nga gipang istorya
gibalik istorya naitig record gibalik
o naitag record siya may tig type pero mas commonly nga ginagamit nila is typewriter hindi lang kung kuman o laptop na rin
kuha na siguro ba sa una kasi kung
typewriter man daw.
Section 3 rights and obligation of a witness. A witness must answer question although his answer may tend to establish a claim against him. To be protected from irrelevant, improper, or insulting question and from harsh or insulting demeanor. Not to be detained longer than the interest of justice require. Not to be examined except only as the matter pertinent to the issue. Not to give an answer which will tend to subject him to penalty for an offense as to the rest provide the law. Not to give an answer which will tend to degrade his reputation unless it to be very facts at issue or to a facts from which the fact is in issue which would be presumed but a witness must answer the fact of his previous final conviction. There is na yung mga rights and obligations sa isa ka witness is dapat is ang kuan is protektahan sab niyang dapat direct insult kung unsay iyang ikuan.
In the dress section 3 rights and obligation of a witness, it means ang kanaang usa ka kuan protektahan ang usa ka witness diyan siya rights very that to be protected from irrelevant, improper, or insulting question diyan during sa kanaang ibali sa korte hearing kibali diyan ang isa ka attorney sa pikas nga grupo is mangutana sa iyaha dayon kuanan siya pangutanan siya ng mga questions which is irrelevant or dili connected sa case dapat dili diyon buhaton sa kato ang PICAS grupo or sa lagi sa PICAS grupo dayon. For example, para ra sa kana ang rights of a person being arrested, di ba doon nabot siya rights nga kanang i-istorya sa police nga you have the right to remain silent, you have the right to have kanang competent kanang attorney, you have the right to get an attorney. Kung dili ka maka-afford na makuha ng attorney is kanang mag-provide ang kwan sa imo, government sa imo ha. So ang best sab sa kuan during pud sa presentation of evidence, ang witness po is given po siya rights during sa court hearings ba diha ang then kani ang 1 to 5 mao ni siya ang rights and obligation sa witness. Like for example, the obligation to give an answer which is going to subject him to a penalty. Diyan mingon pangutanon siya dayon dili siya motubag maghulat kibali siya mingon siya nga kana ang no comment. So obligation na siya or right na niya nga moingon nga kanang dili ana siya mo answer kailangan niya ang ija attorney. Mao na ang obligation sa usa ka witness nga dili.
Or Section 4, order in the examination of individual witness. Direct examination by proponent, cross-examination by opponent, redirect examination by opponent, recross examination by opponent. Amo na Section 5, direct examination. Direct examination is the examination in chief of a witness by the party presenting him on the facts relevant on issue. Cross-examination is a purpose and extent. Upon the termination of direct examination, the witness may be cross-examination by adverse party as to many matters stated in the direct examination or connected therewith sufficient fullness and freedom to test his accuracy and truthful and freedom, interest or bias, or the reverse elicit all important facts bearing upon issue. So diri amo yang pagkuan ng kanang pangutana o kibali sa pikas gani kibali ng kuan amo. Yung mga tanong ka na sa isa ka kuan papanig.
Yan din sa paano sa direct examination is kung kinsa kibali ako sa ka kanaang kon lawyer sa katong victim, then ikaw witness tagwat ikaw as kanaang mo panig sa mo ang imong ibulgar kung ano tayo mong nakita. Ako nga nagkuha sa imo, ako ang nag-question sa imo ha as witness nga imo ang ipakita kung imong istorya kung ano tayo mong nakita. Kaya ako may nagkuha sa imo as witness, ikaw magkuha na ako nga witness, ako yung mag-question sa imo ha. Mo to sa cross-examination is ang katong lain nga panig na pod ang mag-question sa imo ha. Sa cross-examination.
Section 7, redirect examination, its purpose and extent. After the cross-examination of witness has been concluded, he may be examined by the party calling him to explain or supplement his answer given during the cross-examination or on redirect examination question on matter not dealt with during the cross-examination be allowed by the court in its discretion. There is after sa mahuman sa pangutana sa witness na then nahuman na kibayas pa-examine imo daw kung ano sabi explain pangutana sa botro examine sa botro ng isa kakuan witness. Section 8, cross examination. Upon the conclusion of the redirect examination, the adverse party may cross-examine the witness on matters stated on this redirect examination and also on such other matter as may allowed by the court in its discretion. Section 9, recalling witness. After the examination of a witness by both sides has been concluded, the witness cannot be recalled without leave of the court. The court will grant or withhold leave in its discretion as the interest or justice may require. Then, Section 10, leading and misleading question. A question which suggests to the witness an answer examining party desire is a leading question. On cross-examination, on preliminary examination, when there is difficulty getting direct and intellectual answer, witness so ignorant or child of an unwilling or hostile witness, or witness so is adverse party or officer direct in managing aging public or private corporation or the partnership or opposition with the adverse party. Section 11, impeachment of adverse party witness. The witness may be impeached by party against whom he called by contradictory evidence by evidence that his general reputation or truth, honesty or integrity is but by evidence that he has made other times inconsistent with his present testimony, but not by evidence of particular wrongful act, except that may be shown by examination of the witness on the record of the judgment and has been convicted of the offense. Section 12, party may not impeach his own witness except with respect to witness referred to paragraph. Section 10, the party proceeding witness not allowed to impeach his credibility. The witness may be considered unwillingly or hostile if so declared by the court upon adequate showing his reverse interest and justified reluctance to testify or his having misled the party into calling him with his stand. Section 13, how witness impeach by evidence of inconsistent statement. Before a witness can be impeached by evidence that he has made of other times statement consistent with his present testimony, the statement must be related to him with the circumstances of the times and places and the person present, and he ask whether he made such statement, and if so allowed to explain them. The statement being written, they have been shown to the witness before any person input to him concerning them. Section 14, evidence of a good character of witness. Evidence of good character of witness is not admissible. Evil character has been impeached. Section 15, inclusion and separation of witness. On any trial hearing, the judge may include from the court any witness not at time under examination, so that he may not hear the testimony of other witness. Section 16, when witness may refer to memorandum, a witness may be allowed to refresh his memory respecting a fact by anything written or recorded by himself or under his direction of the time when the facts occurred, or immediately thereafter, or at any other time when the fact was fresh in his memory and knew the same was written recorded. But just case anything recorded must be produced and be inspected by other party who may he chooses cross-examine the witness upon it may read in the evidence. Section 17, when part of transaction writing or record given in evidence, the remainder admissible. When the part of the act, declaration, conversation, writing a record is given evidence by one party, the whole of the same subject may be inquired into by another, and when detached act, declaration, conversation, writing or record giving evidence of any act, acceleration, conversation, writing, record is to understand may also given in an evidence. Section 18, right to respect writing shown to witness. Whether writing is shown to witness, it may be inspected by adverse party. Authentication and proof documents. Section 19, classes of documents. Section 20, proof of private documents. Before any private documents offered as authentic assertive in evidence, its due execution and authenticity must be proved by anyone who saw the documents executed or written, by evidence of the genuineness of the signature or handwriting of maker, Section 21, when evidence of authenticity of private during not necessary. Where a private document is more than 30 years old is produced from the custody in which it would naturally be found if genuine and is unblemished by any alteration or circumstances of suspicion, no other evidence of its authenticity need to be given. Should we detail how genuineness of handwriting proved? Handwriting of a person may be proved by any witness who believes it to be the handwriting of such persons because he has seen a person write or has seen writing purporting to be his, upon which witness has acted or been charged, and has thus acquired knowledge of the handwriting of such person. Evidence respecting the handwriting may also be given by a comparison made by the witness or the court with writing admitted or treated as genuine by the party against whom the evidence is offered or proved to be genuine to satisfaction of the judge. Section 23, public documents as evidence. Documents consisting an entries in public records made in the performance of a duty of public officer, prima facie evidence of facts therein stated. Section 24, proof of official record. The record of public documents referred to in a paragraph, section 19, when admissible for any purpose, may be evidenced by an official publication thereof or by a copy attested by the officer having the legal custody of the record or his deputy accompanied of the record to keep in the Philippines. Section 25, what attestation of copy must state, whether a copy of documents or record is attested for the purpose of evidence. The attestation must state in substance that the copy is correct copy of the original or a specific part thereof as the case may be. The attestation must be under the official seal of existing officer, there be any, or if he, the clerk of the court, having a seal under the seal of such court. Section 26, irremovability of public record. Any public record, an official copy of which is admissible in evidence, must not be removed from the office in which it is kept, except upon order of a court, whether the inspection of the record is essential to just determination of the pleading case. Section 27, public record of a private documents. An authorized public record of a private documents may be proved by the original record or by copy thereof attested by the legal custodian of the record with an appropriate certificate that such officer has the custody. Section 28, proof of black record. A written statement signed by an officer having the custody of an official record or his deputy that after diligent search no record or entry of a specified tenor is found to exist in the record of the office accompanied with the certificate approved provided is admissible as evidence that record of his office contain no such records or entry. Section 29, how judicial record impeach. Any judicial record may be impeached by evidence, one jurisdiction in a court or judicial officer, conclusion between parties, fraud in the party offering record, in respect of the proceeding. Section 30, proof of notarial documents. Every instrument duly acknowledged or proved and certified as provided by law may be presented in evidence without further proof. The certificate of acknowledgement being prima facie evidence of execution of the instrument or document involved. Section 31, alteration in document. How to explain. Party producing a document genuine which has been altered and appear to have been altered after its execution in parts material to question and dispute must account for the alteration. Section 32, seal. There shall be no difference between sealed and unsealed private documents insofar as their admissibility as evidence is concerned. Section 33, documentary evidence in an official language. Written in official language shall not be admitted as evidence unless accompanied with translation into English or Filipino. To avoid interruption of proceeding parties or their attorneys are directed to have such translation prepared before trial.